what you're saying.
All right. Thank you very much for joining us this afternoon. I wanted to give you a quick update on the preparation that I've taken to deal with the Menendez case. As I said when I came into office on December 3rd, I was going to do the thorough review of the facts and the law that I will do in every case, whether it's a media attention-driven case like the Menendez case or any other type of case. In the Menendez case in particular, what that has involved is reviewing thousands of pages of confidential prison records to analyze the rehabilitation aspect of resentencing. It has involved reviewing thousands of pages of trial transcripts from 2 months-long trials. It has involved talking to all the different prosecutors who've been involved with the Menendez case, defense counsel. It has involved reviewing voluminous exhibits and pleadings and court filings, not just at the trial level, but at the California Court of Appeals, where the Court of Appeals affirmed these convictions, and again at the Ninth Circuit Court of Appeals, where they again affirmed these convictions. So we've been doing that effort, and that effort continues. As part of that effort, what I said is that I would also speak to any victim family member who wanted to speak with me. And that's what we did today. A number of the victim family members came in. It was a very productive session where they gave me all their thoughts about what should happen in this case, their experiences that they wanted to share, the ultimate direction that they wanted this case to go. And so it was a very productive conversation over a number of hours. Again, I invite and have continued to invite any additional victim family member, and I think virtually all of them were there today, that wanted to speak with me to speak with me. And that forms part of the information data set that we will use to determine what the right result should be in both the habeas proceedings, although the impact, the family victim members' impact is less important as far as a habeas proceeding goes, as well as the resentencing issues that are going to be coming forth. Right now, the resentencing hearing is set for January 30th and 31st. That date is the date we're working against. If it changes, we'll certainly let you know. And we will continue to do this difficult but important work of reviewing the facts and the law to make the right decision in this case. So that is the remarks I wanted to start with. I'll now open it up for any questions. What I'm doing is processing all this information. So we have not finished the review, for instance, of all the prison files. Again, it numbers in the thousands of pages, covering well over 30 years of prison experience for both Lyle and Erik Menendez. Nor have I finished reviewing all the trial transcripts as well. But we're inputting that additional information that I received today, which was useful information, into the entire decision matrix on what to do with this case. And the court ultimately has the final call on first whether it wants to reconsider the sentence at all, and second, if it does want to reconsider what the new sentence should be. And the state legislature, through the laws of resentencing, has given the court an enormous amount of power to do that. And as you're aware, depending on the sentence, if the sentence provides for the ability to then have parole, and that would, in the Menendez cases, potentially impact the youthful parole statutes that have also been passed, then the decision would ultimately go to a parole board on whether or not to grant parole. You look at each individual crime separately. There's effectively 3 crimes that they were convicted of. One dealing with the first-degree murder of Jose Menendez, their father, one dealing with the first-degree murder of their mother, Kitty Menendez, and then a conspiracy statute tying them all both together. So you would look at each individual crime, and then each individual for the resentencing's rehabilitation. Now, that might lead you to the same results. It might lead you to different results, and I'm not here to predetermine where we're going to end up for each individual defendant and each individual crime. That's what this analysis is all about. It's taking a lot of time, but it's one of those decisions that you want to make sure you get right. So I'm working with a team of people that are also engaged in reading these transcripts and then bringing to my attention the transcripts that they're reading. I read those transcripts. So it's there's not a lot of free time in my life right now, but that's okay. I didn't sign up for a job that said I was going to have a lot of free time. And so we're going to spend the time necessary to get this decision right.
Can you talk about how many attorneys in your office are working on this and whether you think a decision by your office can be made by that January 30th date?
A number of attorneys are working on this beside myself, and right now that January 30th date is a date that we intend to hold to. Again, if something comes up that militates us asking for additional time, we'll certainly go to the court before we would go to the press, and then we afterwards let you know. So thank you all very much. Appreciate it.